Well, thank you, Preet. Thanks, Elmar. Thanks to all of you for being here with us this evening. Coming up, we have not one, but two panels talking about important areas of regulation and enforcement. And we're going to start with two very important areas overseen by the Commodity Futures Trading Commission and the Federal Trade Commission. The CFTC, as you probably know, is the leading US derivatives regulator that's shown a particular interest in digital assets and artificial intelligence. The Federal Trade Commission regulates mergers and acquisitions and also consumer privacy, and has been very active in both of those areas. And we have two speakers with us, two ideal speakers, I think, to talk about these two agencies and their activities. On my immediate left, I'm very pleased to welcome Kristin Johnson, who is a commissioner with the CFTC. She has held professorships at Emory University and Tulane Law School. She's taught courses in securities and derivative regulation. She stood in your shoes as an assistant general counsel of a financial institution, and she was with the law firm Simpson Thacher. And then on the far end, I'm joined by Bill Kovacic, who is a professor with George Washington University Law School, where he leads the Competition Law Center. But he also spent several years at the Federal Trade Commission, including serving as chairman. Bill is also a non-executive director with the UK's main antitrust regulatory authority, the Competition and Markets Authority. Kristin, I want to start with you. The CFTC has had a particular focus on fraud and manipulation in digital assets. In the audience here, we have a lot of GCs. Some of them are from financial institutions, but they're also from all kinds of other businesses. Should they all be paying attention to this area?
So thanks so much, Nick, for having me. I'm grateful to the sponsors of the event. I'll start with an anticipated disclosure. The views I'll share tonight are my own. I will work hard to persuade you and my other commissioners to adopt them, but they're mine in the moment. I would suggest actually taking a step back and drilling down if we could. And the step back I'd suggest we take is to the underlying technology that really is the source, or at least crypto is merely a use case, if you will, for distributed digital ledger technology, commonly or colloquially referred to as blockchain technology. So in the context of the broader conversation, continuing the discussion from the previous panel, there are a number of emerging technologies that really are poised to deeply impact how we function in any business and in many other parts of our society. So there are use cases for blockchain technology that touch traditional finance and parts of our markets that are quintessential to how we clear and settle and trade transactions, how we facilitate and execute banking transactions, and possibly how we facilitate the businesses of a diverse number of sectors of the economy, everything from supply chain monitoring and tracking in the context of the movement of manufactured goods and services to agricultural or environmental or sustainability initiatives. So there is a broad set of use cases for the technology. The one that we are most frequently interfacing with currently is the use of this technology to generate coins or tokens that represent some kind of value. And in part, that arises out of something that Preet mentioned in his remarks just a moment ago, an unsettled area of law that, as a law professor, I'm thrilled to spend hours discussing ad nauseum, that arises from a 1946 Supreme Court decision that really left open how we interpret Section 2A1, the definition of a security in the Securities Act of 1933. It has worked well for us to have that dialogue between the SEC and the CFTC for many years. We have had or come up with solutions, even in the face of innovation previously. In the context of over-the-counter derivatives, the Dodd-Frank Act imposed a very thoughtful solution to how the SEC and CFTC could exercise co-oversight of certain areas of swaps markets. I think for the crypto markets, we'll see something very similar. But in the current moment, we've had over 133 crypto cases in the course of recent years that have been focused on fraud and market manipulation. Our authority in the fraud and market manipulation space is quite broad by statute. Regulation 180, growing out of Section 6 of the Commodities Exchange Act, which parallels Section 10B of the Securities Act, the Securities Exchange Act, gives us far-reaching authority, if you will. So definitely lots of muscle to flex in this space, and maybe some really interesting theories. I'm happy to come back to this later or in Q&A that we are now pursuing. So one good example of that would be in the Binance case. We brought up a formal action against one of the larger current cryptocurrency platforms. And not only did we allege very traditional claims regarding how the business interfaces with US customers, including failure to comply with AML and KYC requirements, we also brought an anti-evasion case, which is the first of its kind. And we brought that case largely because the business argued that it exists everywhere, but is at once nowhere. All at once, it's nowhere registered as a headquarters, and therefore its business did not touch US customers and US soil. We used some surveillance and investigative techniques to identify communications, particularly on offline communication channels, namely some platforms that a few of you may be familiar with, WhatsApp and Signal, and those communications enabled us, we believe, to establish that there is a basis to conclude that the firm was aware of the fact that they had US customers. They had not engaged in that preliminary Bank Secrecy Act KYC AML compliance. And as a result, we sort of pursued the one case there.
I just want to pause for a second here. You mentioned some of the other use cases of blockchain technology, and I'm interested to hear from the audience. Has anybody here experimented with that, whether in finance or other kinds of use cases? Is anybody aware of that in your companies? It looks like it's still fairly early days, so, but something for them to be thinking about. Just to move in a slightly different direction here, there's been a lot of discussion about digital assets and links to national security issues and the CFTC's role in that area. Can you give us your take on how the CFTC fits into what's going on in the broader world in terms of digital assets and their use and abuse?
Well, I think what we'll see in this big parallel piece of the conversation we'll have shortly about generative AI is that there is a global race to establish standards. In the context of crypto, the place that I would point us to in terms of other jurisdictions and the progress they've made is Europe, and specifically the MiCA legislation that has been launched there. Here in the United States, most of you will probably be familiar with the fact that Congress has many pending bills, but has not yet advanced a single initiative that has sufficient support as of the moment publicly in terms of what's been reported, that there would be a single bill that resolves sort of questions regarding regulation of this emerging asset class. In Europe, however, a bill has been passed to sort of close the gap between where regulation left off in the early 2010 period with MiFID, and now sort of closing the gap to make plain that regulation and regulatory oversight will apply to crypto. So here in the United States, I think we're spending a significant amount of time focused on how to best craft regulation to address emerging technology. And crypto is one example, blockchain is another, generative AI could be a third. But certainly is the case that we're now grappling with or wrestling with whether our rules are fit for purpose or whether there should be regulation or legislation created specifically to address some of these technologies.
And AI, so this came up in the Almar's conversation with Preet Bharara, but AI has got a lot of excitement because of ChatGPT, but it's actually been used in the financial world for a lot longer, hasn't it? Built into the algorithms of trading models and so on. What have we learned, and Bill, feel free to weigh in here, what have we learned over the years of the risks and regulations around AI generally in its use in finance?
I think first, thank you for the wonderful privilege of joining the panel. I think there are a couple of acute sources of anxiety. One is the sense that the new technology is akin to the sorcerer's apprentice, that it does wonderful things, but it quickly gets out of control. and not because of malice, but because of inadvertence, an inability to anticipate where things are going. And that because there's such a perceived imperative to roll out the technology as fast as one can, there's a sense that where there are problems, we'll fix them later, but not now. And that inadequate attention is being given now to thinking about bad case scenarios, what could go wrong. And that this is a common concern about highly dynamic, technology-driven sectors. The second is one that Kristin mentioned before, which is the sense that the US is going to lose its place in shaping policy. There's a sense that the US missed the train on data protection. That is, we do have a national data protection policy. It's called the GDPR. It's called the state of California. And there is no evident sense of urgency in our Congress right now to do anything about it. I mean, we could drift another 2, 3, 4 years without having a national framework. In platform regulation, it's called the Digital Markets Act, which is shaping policy. And there's an evident pride that the European Union takes in being the global standard setter. The AI bill in the European Parliament is being queued up, and there's a sense that'll be first to market and get there. So I think not only is there a sense of concern that we're having fast-moving changes without the kind of testing and vetting that you might see in other settings, and that by the time we turn around to try and address concerns, it will be too late, it will be out of control. And the other is that the US is going to stand on the sidelines and watch all of the regulatory developments happen offshore with no voice in how they take place. I think that's going to propel regulators today, and certainly at the FTC, to try and move quickly to have a voice in the process.
And yes,
I'll pop in there, Nick.
please
I'll
do.
say a couple of quick things. The first is to a point that Bill's making about essentially the black box nature of relying on AI and increasingly on relying on not just supervised machine learning algorithms, but unsupervised machine learning algorithms that are reliant upon data sets that are pre-existing as of the creation of the technology itself, and therefore subject to all the limitations that would have been built into the system with respect to the data itself and the limitations of the coders, right? So, that portion of the discussion I think is really worthy of exploration for most businesses, mostly because there is the fear and the concern around liability, but there is the broader point that I think Preet mentioned and I'm deeply committed to being thoughtful about, and that's sort of the ethical implications for society. So in fact, I wrote an essay called The Ethical Implications of Society on AI, and when I did that as an academic, what I was mostly thinking of and have often just been focused on as a lawyer is my role in mitigating the risks for the organizations that I'm part of. And so what's really a challenge for even the most conscientious lawyer or risk management officer is to hand over decision-making to a technology, a software that will weigh data and make a decision that is inscrutable in some way. That can become even more acute, to use language Bill offered earlier, in the context of legal obligations to explain the decisions that were made. So a very good example I used testifying before Congress about this issue in 2019 is residential mortgage loan applications, or even other broader residential debt questions, and the thought around any denial and the need to explain exactly what the basis for a denial was. So I think the ethical questions that the White House, in the executive order, the series of comments and pronouncements that the White House has made recently about civil rights and AI really go to that broader societal question. I also want to layer in, it's not as neatly fitting, but I think it's a useful observation in the moment, that we at the CFTC are also using AI in a number of ways. And one of the ways you mentioned that the market participants have long used complex algorithms, Nick, is in the context of predicting pricing, predicting flows of transactions, predicting interest in markets. But we as regulators are also using the same technology now, and even more effectively over the last decade. So surveillance of market trends, surveillance of market behavior, surveillance in trading data that facilitates the identification of patterns in trading that lead us to conclusions that there may be something to investigate. I think that use of supervisory technology has enabled us to enhance the integrity of markets and better protect investors, but it also presents challenges as well.
So you mentioned explainability, and that's one of the key things that the audience should be thinking about. Presumably, if you're a general counsel or a head of compliance, what else other than explainability would put you in a good position to actually use AI and not get into trouble with it?
I think a key issue is, do you have the capability inside to know what you're talking about, to understand the technology? Do you have a team that works with the legal team? I'm sure this room is not going to fall into this category, but most lawyers I know have been running away from mathematics since they were in high school. And you do not have, as adaptable and intelligent as they are, and of course they are, you don't have in many instances the technical skills, including in the regulatory authorities. There's a desperate effort now, I think, to catch up and acquire those skills. But I think an absolutely indispensable partnership that has to take place within any enterprise, a public enterprise and a private enterprise, is to have the right team. And if you don't have computer scientists, engineers, quants, analytics to help you and guide you through this process, I think you're completely adrift. And there's a desperate need to rethink what kinds of capabilities you bring to bear on these issues and who you work with inside the company to do this.
And one of the other key issues here, I think, is data use, and what's the FTC's view on AI and its intersection with consumer data?
One of the most important is our companies building what we referred to before as guardrails or safeguards to ensure that data is used for the purpose intended. That firms are not promising one set of controls and doing something else. But more generally, are they building precautions into their systems to make sure that there's not the equivalent of an oil spill in transporting petroleum, to make sure that there isn't a vulnerability that is properly addressed with internal safeguards. So one thing the FTC is looking at very carefully is what kind of precaution taking is taking place inside enterprises. What kind of use and transfer of information is occurring, especially where the firm deals with third parties. The firm's own controls may be first rate, but if there's an exchange going on with other enterprises, is the handoff taking place appropriately? That's a major focus of concern now that goes beyond the violation of specific technical requirements that appear in our remarkable patchwork of privacy protections, but more generally the question of, do you have an internal architecture that in theory and practice provides assurance that information is going to be used in the right way? And here again, tremendous anxiety that the rate of change and the sense that we have to roll things out as fast as possible means that those safeguards are running well behind the actual deployment of the technology. That's an unmistakable focus of what the FTC is doing with its current generative AI investigation.
Kristin, I want to come back to something you mentioned, which is ethics. Maybe that's unfamiliar territory. If you're a general counsel, you've studied law, you haven't studied ethics. Maybe the two are the same. Maybe some of them
That's a slur. We all study ethics. It's at the core of everything we study, Nick.
How would our audience members go about incorporating ethics into their legal and compliance programs?
Well, I'd just love to start with something Bill closed out with and then turn to ethics, if that's okay with you, Nick.
Sure.
The piece Bill mentioned that I think is really critical for us to be focused on is, in fact, critical third and fourth party service providers. We are in the process currently of developing a rulemaking that would begin to focus not only on operational resilience, this is more on the cyber side, specifically than sort of any emerging technology individually, but the use of all of these emerging technologies creates increased interest, increased attraction for purposes of hackers or others intercepting and capturing data or information. And so even if you have first rate, to your point, Bill, blue ribbon practices that you've adopted, many of us are relying on critical third and fourth party service providers to effectuate any number of things from data storage to data analytics. All of this puts, in many instances, the companies themselves at the mercy of the third and fourth party service providers. I suspect that even for a large Fortune 500 company, negotiating with the likes of Google or Microsoft or Amazon can be complicated. And not only am I as a consumer asked to take it or leave it, I suspect that many very large businesses are invited into a conversation where here's the service, here's the fee. Maybe there's some negotiation about the latter, but there's not going to be very much negotiation, and maybe even a black box about the former. So this notion that we would be so intimately tied to and relying upon critical third and fourth party service providers, particularly in the technology space where there may be some obscurity for a variety of reasons, some related to intellectual property, others related to just the inscrutability of the technology itself, all really poses a unique challenge, I think, for most regulators. Because while we may have some regulatory authority over a registrant who is directly entered into our market, who is producing goods and services that are subject to law, and therefore they are subject to our authority, the critical third and fourth party service providers on whom they are relying for many important tasks may have no such obligations. And so this conversation is one that I'm not just having across DC with other regulators or even with banking authorities at the Federal Reserve. I'm also having these conversations with my colleagues at the Bank of England. I'm having these conversations with colleagues at the Bank of France. I'm having these conversations with colleagues at the European Securities Market Regulator. And the motivation is that we have to find a mechanism whereby we can chill the move fast and break things spirit, particularly where for core businesses in our economies, the reliance on those types of technologies is, there's a dependency there. No other way to describe it.
And how do you, as Kristin's just saying, how do you build an ethical culture of compliance, which Preet was mentioning before? You can have stacks of slides, you can have videos, you can have interactive projects, but that becomes terribly sterile in a hurry. How do you build a sense within the enterprise that you have ethical decision making? And it's not realistic to think you're going to have no lapses as long as human beings are involved in the process. Ever since those two people got kicked out of the garden, there are going to be problems, there are going to be failures. I think the realistic aim is to minimize the size of the lapse and, crucially, to take steps to see that it's not replicated. I mean, there's not necessarily shame in making the first mistake, although some first mistakes are fatal. It's doing it again and again. And I think one of the interesting ways to teach this, I find, and not just for academic purposes, is I love case studies. I'm not so much interested in the fact that there was a flaw, it's interesting to know why. And using case studies, you can use them that involve fast-moving technologies. The development and deployment of the Titanic is a wonderful case study where they had basically an hour and a half of sea trials total before they decided we're ready to go. Nobody had quite had the experience handling a vessel like that. How fast does it go? How quickly do you have to turn? There are wonderful examples. Challenger is another one where you can have vivid reconstructions of events and you put decision makers in the position of saying, what would you have done there? And of course, it's more difficult. You understand the pressures that people are facing. Yeah. But I think a valuable element of the vivid case study is to understand the pressures that lead to specific choices, and in particular, where tech's involved, the value of having an internal adversary squadron whose job it is, your job is to figure out what could go wrong.
Yeah.
Your job is to look for the flaws, and we'll address them.
I just want to pause for a moment here, and we're open for questions. If you have a question, raise your hand, and we'll bring a microphone to you. If there are any questions at the moment, then we can take them, but I also...
While the microphone's running, while someone's running,
yes,
drop the microphone.
Please.
I don't know that we need case studies that are completely historic or simulated, because it seems we're living through many just right now. So for us in the derivatives markets, a very little known private company named Ion had a fairly significant cyber event in January. And that cyber event created an exceptional quiet across derivatives markets almost instantly, because it was providing back office services for a significant number of market participants. So our ability to reconcile end of day trade data, which is a critical piece to determining margin and collateral across the market for the very next business day, right? It was disrupted. And the subject of the cyber incident was merely one impacted party. The many businesses that trade and execute transactions relying on information that would have come through that entity really illustrated for us the need to engage in tabletop exercises or to continue to increase the number of tabletop exercises we engage in across our markets, which is to say actual simulations of events and actual response to the question of, in the event that we have an outage, in the event that there's a DDoS attack, in the event that there is a cyber incident that involves ransom, how do we shift markets in a way that enables us to continue to be successful at doing
these are tabletop exercises within the agency, or you're also looking for the firms to do it themselves?
We're wholly expecting, and part of, I sponsor a market risk advisory committee within the CFTC. And so in March, we had a hearing essentially on the specific cyber incident that I just mentioned. Part of the motivation for that was to call the industry forward to tell us about what had happened as much as could be shared publicly, because that disclosure would be valuable among peers, right, within the market. But also for us to point out that to a certain extent, we wouldn't be the first best choice. The agency isn't the first best choice to lead some elements of this simulation. To a certain extent, we need industry trade associations to take up the mantle and be leaders in calling together coalitions of the willing to begin the process of simulating what it means to be unable to fully perform various functions as the most significant counterparty on certain types of trades or transactions or whatever else.
Yeah, well, I'd like to learn as fast as I could why it happened. You know, what were the avoidable errors, what were the unavoidable errors, and to try to identify that. I'd almost want to impose it as a condition of settling cases. That is, I don't know if there'd be a great public revelation, but if we're going to have a settlement, you're going to find out why it happened and talk about it. That becomes part of a good compliance culture to discover that. You know, I'm struck, for example, in the aviation sector, where I had occasion when I was in private practice to study airplane crashes. The ferocity with which airlines and the manufacturers try to find out what went wrong in order to avoid a repetition, with no sentimentality about what took place, to try and fix it. The collaboration with the aviation authorities. I mean, that's the compulsion internally and externally that I would like to see to find out what took place. And as a general counsel, identifying that, I think, tells you something about what to look for in the future. That is, where are the lapses in decision making, where are the breakdowns? Some of them, as you see in aviation, are unavoidable because you're dealing with unknown circumstances. But there again, it's to find out why did it happen, what kind of safeguards can you put in place?
We only have a few minutes left, and again, we can take questions if there are any.